All right, well, we're here with Ernie, the Montana living man, and Ernie's had quite a go at things recently, and we're here to update you on things. He's now officially out of jail, and so Ernie, tell us what happened.
All as usual, what happened. Those folks would stand up for the Constitution and country end up being put down in some form or another. That's pretty much what happened. I had utilized elements of the Constitution and much research regarding statute and code versus actual law. And in the past, there's so much I've done that hardly anybody knows about. I had already established a precedent-setting case on the 23rd of March in Gallatin County, DPO 8-59A, in Federal Judge Holly Brown's court, that evidenced how it is I'm not in the federal jurisdiction. Based on the driver's license and such things, the evidence on the books is that those kind of licenses are for federal citizens. If you're not a federal citizen, which is clearly laid out in the UCC, it requires one of three ways. You either have to be naturalized, in which immigration is involved, or you have to contract to join the military, or you contract to run and hold public office. If none of that is you, then according to Title 18, Section 22, you're not a federal citizen. If you're not a federal citizen, you're not in commerce. If you're not in commerce, licenses are non-requirable of you. Based on all this, I had been running around the country just being me, living my life, and doing it without the driver's license. Mind you, I sent in a 13-page challenge based on all this to our State Attorney General, Tim Fox, and the State Governor, Steve Bullock, would be 2 years ago this March. Just past March, and I've never heard a word back. No matter how I pushed, I've never heard a word back. Anytime you require an answer of somebody and the answer comes back in silence, that's called tacit admission, meaning that essentially they consent to whatever charge might be framed within your question, as you're wanting to know something, and if they don't tell you the answer, then you're going to have to make a charge of some kind that either they're incompetent and don't know how to answer, don't know what the answer is, or perhaps they're expressing criminal reservation, criminal mentere, as it's called in Black's Fifth Law Dictionary, and are very hesitant to actually address the challenge you've brought to them, which I've done repeatedly, several different locations. All that being said, this again was part of the issue on 22nd of March, series of steps related to a series of arrests in which I was charged with driving with a suspended license. Driving is a commercial term. There's over 3,000 settled court cases on this. It's a federalized term for commerce. Once again, if you're not involved in commerce, driving is a word that's a commercial term, and it requires interstate commerce, the passage over state lines of someone who is bearing persons, goods, chattels, cargoes, things for the purpose of gaining revenue. Okay? It's a commercial term. I'm not in that, and I don't cross interstate lines. I have no need to, really, so I just live around here. And B, I know that the driver's license thing is not about your ability to drive. It has no bearing on your comprehensive ability to handle a motor vehicle. The driver's license, as it is per se, is there to swing you into a jurisdiction. If the jurisdiction that it swings you into is the wrong jurisdiction, then you have to be brought into the jurisdiction as property. If you're just an American and a state citizen, and you're not involved in commerce, then the jurisdiction that pertains to you is called common law equity. It's equity court, in which only that which is just, fair, and right is done. In other words, that which is just, fair, and right, if you're not involved in commerce, then it's just, fair, and right that a commercial license not be required of you. All right, so these are parts of what causes me to be in constant conflict here. And of course, the maxim is that whenever there's a conflict between law and equity, equity always prevails. Equity is stronger than any other form of law. It's a common law, and in Article 6 of the 1789 Constitution, it is identified as the supreme law of the land. Another hidden fact that's in there, an allegation is made that I had refused to pay fines relevant to the driver's license issue. I want to clear that up. That absolutely is an untruth. I hold the evidence, absolutely, that those tickets that were written to the tune of $285, I properly signed them according to the UCC and released those tickets back to Stormy Langston, the local municipal administrator, who is holding that ticket, refusing to let it go into the stream of commerce. Now, that in itself is a crime. To withhold a signed document that has to do with a navigable bond, to hold it after it's been properly signed, and then to accuse the signer that he never signed it, is a crime within itself, and it bespeaks double-minded incompetency is about the only way I can say it. If you don't comprehend contract law, you got no business being a municipal administrator or holding any other position of office, especially when it's in public service. So there's glaring errors through this entire mess. I have tried repeatedly to get this driven to fair trial. I have prevailed at one trial, was on the 27th of May of 2014 in Gallatin County. I prevailed there and evidenced that I'm not a federal citizen by identifying what the federal citizen is, who is the slave. I identified to the jury that I'm not the slave, I'm the living man, separated myself from that corporate slave in the eyes of the jury, did it all in about 18 minutes, took the jury 6.5 hours to deliberate, figure out everything I said, and then I won a not guilty ruling, and so on. I've worked hard and I've done a lot of things. At this point, I believe my life is in danger. I believe I've brought forward the heaviest of all information that's available on the books. I've brought forward, and it's now on file at the court down in Libby with Matt Coof, Republican judge, the 30th of June 1864 Roadman Act of Congress, which undoes the idea of state sovereignty, which such undoing is contrary to Article 6 and renders Montana into the state of no standing. Notwithstanding, has no standing. The Constitution of this corporation, which is not an organic state, as was required by the 1793 Equal Footings Act, it was denied that actual sovereign statehood 27 years before they even applied in 1889. This is the information I've been looking for and driving for. Compounded by the revelation of the knowledge of what SCOTUS, Supreme Court of the United States, did in 1851 and was conjoined by Congress in 1852, which in a highlight fashion means that SCOTUS scoured the 1789 Constitution for some kind of a breach, a semantical backdoor, a breach into it to use, wherein they could gain the appearance of constitutional validity while in fact working at bringing the law of the sea maritime into all the courts and across all the land as if that maritime jurisdiction is supreme over the supreme law, Article 6 of the land. There's only room for one supreme. It's already been written. It's priorly established. It's in Article 6. I drew great attention to this, great attention to the standard that was flying in the courtroom that day. I brought my own standard of the land. It was actually the 2nd of April, 1864. It was introduced by Benjamin Harrison at the order of Abraham Lincoln, and it is known as Peace Upon the Land Standard. It is the right standard for common law equity. I had it with me. I identified what it is. I identified the court's flag as the maritime. I did it 3 times. And you will notice that not one time did the prosecutor nor the administrator object or rebut or even question what I had to say. No, there was no flare-up until they began to realize that I had already taken command of their ship, had swung the ship about, was re-navigating it, and using 19 potential jurors in the pool to do it with, and was going to run away with the entire thing again, as I did in Gallatin County, because what I have to say is so. It holds water. And they knew that they couldn't overcome me. The prosecutor put it into print in a packet of discovery, and unless the municipal administrator erased everything that I'd filed in from the record, that it would be impossible to overcome me. That's because what I filed in is not my opinion. It's everything that's on their books. I just introduce them to what's already been written from their jurisdiction and why it's not my jurisdiction. I'm not to be dragged into it. Furthermore, I backed it with Roman treaty law, which is Hague International law, which says that any time the occupiers of a territory force the dwellers of that territory to take on the personage as if those dwellers were the occupiers themselves, then this is known to be a crime international against humanity. That is exactly what is done as the United States, which is a London banking cabal, overthrew, via the course of the Civil War, the country called America, introducing the end of that overthrow in 1871, the corporate phoenix arising in that year, showing forth its own charter for trade and commerce, dealing with the enemies, the Trading with the Enemies Act. It's very deep. I'm trying to bring it all to a head. I need to be heard all the way through a trial. I would love to be contacted by a brave and honorable attorney who is constitutional and is not one of a turned mind, but who can see these truths, comprehend them, speak them clearly and straightly, and bring this on fire issue straight to the Supreme Court of the United States, who are the ones that are supposed to give answer to this. And it will be noted that since the year of 1851 they have flat refused to give answer for what they have done. At this point I have no choice left to believe but that the Supreme Court of the United States also is utterly criminal in their intent, as they are found to be contrary to Article 6, meaning they too have no standing. At this point, because I believe the danger level concerning me has reached such a crescendo, judging by the violent assault that was perpetrated on me by the arresting officer and the prosecutor, it looks to me like they're just going to sell me down the river for the next 20 years, maybe a mental institution or federal penitentiary, one or the other, when in fact I've done no wrong and have done nothing more than stand for my country, our Constitution, and the truths that are on the books. None of this did I write. I simply can see it, I can find it, I can link it, and I'm exposing it. And of course that's what they fear and hate more than anything. So, in my best interest, because my sole desire and my higher vision is to serve the people, I can see that it's time for me to diverge from this path. And in doing that, I'm going to go ahead and begin to relicense the straw man. I will separate him from me by 3 degrees via the correction of status program. And as best I can, I will navigate upon the land and be of good service to my fellow Americans, all while maintaining my principles, my constitutional platform, and my positive alignment with our country's founding document and positive law. And that's where I'm at right now.
How long were you actually in jail for?
A short 43 days. I did 3 sentences back to back. Contempt of court, 5 days. Assault, 23 days. And driving on a suspended license, 15 days. So it was 13, 14, and 15, and I broke my great-granddad's record. He was arrested 14 times in Albany, New York, 1672. I've just come through number 15.
So what's the next day in court going to be?
At this point, I tried to call my attorney that I'm utilizing, the public defender, Liam Gallagher, this afternoon. I could only leave a message and I never did hear back, so this will be my record for what it's worth that I followed through in fact. We need to establish we need to go over the court's latest preferment to contract. They're hoping that I will plead guilty to a misdemeanor of resisting arrest in exchange for all the felonious crap to be dropped that they dreamed up against me. They've tried to charge me with assault with a weapon, and unless you call the Constitution of 1789 a weapon, there was no weapon in the courtroom of any kind that day, at least not in my physical possession. I had nothing but me and my Constitution, that's all. So, so far it would seem that June 4th coming up would be the next court action. That is alleged to be an omnibus hearing of some kind to see if I'm going to go for the plea bargain, which again grants them jurisdiction. But here I would remind the viewer, you cannot grant them what they stole in 1861 to 65. They flat stole it. They took it by force, military and martial. It's not about granting them jurisdiction. They took it, and it's carte blanche all across the land, coast to coast, sea to sea. They already did it. You can't grant them what they took 144 years ago. So we'll see if this advances on June 4th, whether we go to plea bargain and I try to go ahead and put this down quick, or do I press it to federal trial on 4 of September 2018. Thus far, my instincts are warning me that the federal jury will be absolutely biased and handpicked for sabotaging your country's constitution and everything that's on the books, and I will not be able to win it because they will be predisposed to bias, and it will be a shut case before it even gets opened. So I have to weigh it out and see what happens.
All right, anything else you want to add?
Keep the faith, keep your powder dry, keep yourself in line with positive law, never live in fear, always look for the higher good in everything, keep your eye on the higher road, and be a good servant to your fellow man. Bless the land, treat each other honorably with respect, put some value to your name.
All righty.
And I need my tri-horn back. I dug out my next best fancy hat, and it's the last one I got.